Bill Henshaw here again, your friendly local constitutional consultant out here in California. And this video is going to be on all the recent events you've seen with the redistricting and all the other bureaucratic BS, especially in Texas and California. And for example, where I am, California has 52 members in the House of Representatives. Wow, that sounds great. That's well more than 10% of them, crying out loud. And yet it's nowhere close to what it should be, and it isn't for any other state in the union either. But at the outset, I must say, and you're going to learn, that there are no sovereign independent states remaining which were admitted into this union. Send me an email, uwinnincourt@gmail.com. You're going to learn all about that and a hell of a lot more. But getting to the point here, 52 members. Now, Article 1, Section 2 provides that maximum ratio of representation is 30,000 to 1. That has not overtly been repealed. Nowhere in sight. If that's the case, wow, think about this. California would be entitled to somewhere around 1,300 members in the House of Representatives. And that's a lot more than mere numbers because now you have much smaller districts to deal with. And younger people like me that have studied now and are educated can run in much smaller districts, and they'll be among their friends and family and this, that, and the other. It's just so much better. And they can do that and not be beholden to the Democrats or the Republicans. And we'll have independent voices, in the House of Representatives, which is exactly what we should have. But that House of Representatives, my goodness, 438 members, it's been stuck on for almost 100 years. And they should really be having close to about 1,450. Oh, no, maybe more than that, come to think of it. But nevertheless, the numbers are way off unless the Constitution gets lawfully amended, which can happen. But that hasn't happened. And then the Senate is potentially worse because now all the senators are elected, 8 for 6 years, pursuant to the 17th Amendment that also doesn't exist. And what that did was take the states completely out of the mix in Washington, D.C. There's no Republican form of government in any state in the Union, even if some of them remain in existence. And I take the position that they don't, and I do that with attitude and with authority. But yeah, and not only that, but now there's no Republican form of government. Article 4, Section 4 of the U.S. Constitution guarantees that. Yet the Supreme Court has called that a political question. But you're going to learn that happened in a case called, I'll get it for you in a second. It's from 1850, Luther v. Borden. And at that time, it might have been a political question. When you and I get there with our cases in the court's original jurisdiction, it will be anything but. And they have the sworn duty to answer our questions. You're going to learn all about that too. That's how great of a job those racist framers did in setting up this government. We have the right to be there, and the judicial court in particular, because with no judicial courts, what you're going to learn is that any and all allegedly applicable laws on the books are null and void, non pro tunc ab initio, aka from day one, as bills of attainder. It's either Article 1, Section 9, the feds can't do that. Article 1, Section 10, the states can't do it. And that's a major winning argument here. The hell with all this 14th Amendment bullshit. Due process, equal protection. None of it matters. The amendment doesn't exist. It never has. And you're going to learn that too, which I would love to learn that when I was in 10th grade U.S. history all those decades ago. But that's how good it is for us. You can learn to take control of your affairs. And in lots of other areas too, you're going to be absolutely amazed what happens when you get out from under here with all these fictions of law they're using and treasonous acts to the Constitution. And that's the Constitution mandating it and the U.S. Supreme Court saying it. Case called Collins v. Virginia, 1821. Oh, that's old law. They don't use that anymore. The hell they don't. The current justices have cited Collins on more than one occasion here in the last 5 or 6 years. when they're starting to act like a judicial court. And that's exactly what we need them to do, is to do their sworn duty. Once that happens, Katie barred the door here because all this crap is going to go away. Doesn't matter what it is, whether it's foreclosures, whether it's evictions, child procurement, syndicate. I mean, you name it, criminal cases, ain't all of it goes because you're never in a judicial court, and you're going to learn that our right to a common law judicial court and habeas corpus, not to mention trial by jury, goes all the way back to Magna Carta in 1215. What the hell has happened here? I'm going to teach you exactly what happened and teach you how to get around it and take care of business here. That's the good news. It really is. And it's comparatively simple. I didn't get it right away myself when I started out all those years ago, but it's my job to see that you do that. We're going to be working that out so you understand. But there's not a lot of legalities there or any nonsense like that. Basically, plain English, and you're going to understand, what the rights are, that you have them, and that you can teach your kids and your posterity so they will have them, and potentially better yet, with upcoming generations, with educated members, and they get on a jury, they're going to know they have the power to rule on the facts and the law. And that's been true here since at least 1787, but not so as you notice it today. We don't have any qualified jurors or electors whatsoever anywhere in sight. And you're going to learn all about that too. It's just the way it is, and it's the way the New York banksters wanted it to work out back in the days of Reconstruction, and probably earlier than that, trying to figure out how to get their hands on all the goddamn money and keep it to themselves. Probably have these damn Federal Reserve notes. It defined it all, by the way. If you don't know, they're defined by the president, and that thing is commander in chief of the armed forces. But you probably aren't in the army. And by the way, take close notice here. Every time you see a U.S. flag, uh, and or sometimes most state flags, they're going to have a yellow fringe around it. That's truth in advertising. The U.S. Attorney General ruled in 1921, as you're going to learn, that yellow fringe is martial law jurisdiction. That's exactly what the 14th Amendment is, and we need to get out from under while taking the amendment out in its entirety. It's never been there. It's a great story. You're going to love to hear this one. Never been there from 1868. Wow, that's the magnitude of the deceit, fraud, and treason of these New York banksters. But we have rights and we have ways to take care of it. You're going to love to hear that. Your children are going to love it, and your posterity will honor you even more. That's how good it is. Now send me an email, youwinnincourt@gmail.com. Remember to subscribe, tell your friends, get the word out. The sooner we start invoking our rights, the quicker we get these bastards off our backs. Thank you.